your cross-examination. That's known as the rule in Brown and Dunn, because if you don't contradict what somebody says when they give their evidence, when you're cross-examining, you're taken to accept it. Alright, that's the rule in Brown and Dunn. So you must, if you disagree with what a witness is saying and you're cross-examining, you've got to really make that disagreement clear by putting your case to them and challenging anything that you disagree with. And that's so they've got an opportunity really to answer. If that makes sense. The next thing that we need to look at is about cross-examining witnesses in sex cases. And on the slide it says the sexual history shield in rape and indecent assault cases, and that's section 154 of the Crimes Ordinance, which we have got. So I thought we'd have a quick look at that. That's at page 1 of the Ordinance Pack. So 154 is restrictions on evidence at trials for rape, etc. So if at a trial for the cause for instance any person is at the time being charged with rape offence or indecent assault to which he pleads not guilty, then this in brackets should read out, then except with the leave of the judge, no evidence and no questioning cross-examination shall be adduced asked at trial by or on behalf of any defendant at the trial about any sexual experience of a complainant with a person other than the defendant. Right? So when you're cross-examining a complainant in a rape case or indecent assault case, unless you've got the leave of the judge, you can't ask the person about their sexual history with anybody apart from the defendant. Have a quick look at exercise 12, practical exercise 12, please. Well, I think you could probably work out, think of the reasons why really that's not great, is it? Because before this provision was there, before this sexual history shield was there, the complainant's sexual history would often be gone through by defence counsel cross-examining them, not because really it had any relevance to the issues in the case, but just really to try and destroy the person's credibility, to suggest that they were promiscuous. For some reason that's a bad thing and therefore they shouldn't be believed about this particular matter, so that the jury maybe, they're trying to make the jury feel less sympathy for the person. And you can imagine that will put a lot of women off reporting sexual offences and rape. If you know that your whole history is going to be paraded in public and you're going to be questioned, in potentially quite a humiliating way, that will put you off reporting an offence, I think. So for that reason, we've got the provision that we've just had a look at. So that's an example of questions that you can't ask in cross-examination And again, that was something that, you know, it came up in the summer exam, that very point. There was it was involved in other issues as well, but there was a point about, you know, what you could question a complainant about in a sex case, so worth remembering that. Then the other two things on the slides, again, are about what you can ask, you know, how far you can go in cross-examination. And the rule of finality on collateral issues is there. We're going to go into this in more detail, or whoever takes you for your revision will go into this in more detail at a later stage. But basically, the idea is that the trial sticks to the main issues, and the issues are collateral to the trial, such as just a witness's credibility. Once you've asked the question on it, the witness gives the answer, that's the end of it. You can't go into more and more detail on these collateral issues because trials would go on forever, really. So it's partly a time thing, stops time wasting and gets the court to focus generally on the issues. And so that's the rule in Thunderbunk. There are some exceptions to that, in that you are allowed, so the rule of finality means that once the witness has given the answer, you can't call evidence to contradict it. Right? So that's the rule in Thunderbunk. So once they've given the answer, if it's a collateral issue, that's the end of the matter, and you can't call evidence to show something different. There are exceptions to that, and that is, for example, if a witness is biased. So if you want to demonstrate that a witness is biased, then you can call evidence in rebuttal. You can call evidence in rebuttal where somebody's given an inconsistent statement. And again, we've kind of touched on that already, haven't we, when we've looked at inconsistent statements. Also, you can, if you put into a witness that they've got a conviction and they deny it, then that's another exception. You are able to call rebuttal evidence, right? Just make a note though that I'm talking about witnesses there, I'm not talking about the defendant, because there are specific rules about when you can put previous convictions to a defendant, which we're going to come on to look at in a couple of minutes. So these exceptions to the rule of finality on collateral issues, when I say you can put a previous conviction to somebody, that isn't the defendant unless it's one of the exceptions which we're going to look at. Also, the Rehabilitation of Offenders Act prevents you putting old convictions, so old minor convictions. So again, that was something that came up in the summer exam as well. Other things, so bias, I said that we could demonstrate that a witness is biased. An example of that is the case of Thomas and David. In that case, the witness denied being the mistress of the party who called her, and evidence in rebuttal was admissible in that case. So although so the rule of finality didn't apply, because it was an allegation that she was biased because she was a mistress, then it was possible to call evidence in rebuttal, so you could call other witnesses to say that she was a mistress. That's the case of Thomas and David. Another exception is somebody's had their testimony disbelieved in previous cases. You can call evidence of that, and that's the case of Wong Sao Ming. I think that's involved a number of police witnesses in a case, and the defence were allowed to call evidence that these same police officers had given evidence in a previous trial and had all been disbelieved, because that's obviously they're wanting to demonstrate that these witnesses shouldn't be believed. So if you want to have a look at that, the case book that I've referred you to, it's page 167 in the case book. And in the evidence textbook, so the McConville textbook, when you get that, that's page 446. And that sets out the case, and also you can, if you read the general principles at paragraphs 32 and to paragraph 38, that sets that out nice and clearly for you. And then the final exception is previous inconsistent statements, which we've looked at, haven't we? You can put somebody's previous inconsistent statement to them, and that's relevant to their credibility. All right, so that's, I've forgotten to click onto the next slide. So that's the, those are all of the exceptions to the rule of finality. Right, so the last part then of our session this evening is about character evidence, and there will be one question on character evidence, or wholly, mainly based on character evidence in the exam. And so when we are talking about somebody's character, it can really mean a number of things. So in relation in evidence, what somebody's reputation is within their community. It could be previous incidents, so other things they've been involved with, often previous convictions. So we're talking about somebody of bad character, often really we're talking about the fact they've got previous convictions, whereas somebody's a previous good character, generally what we're saying is they've got no convictions. And it also can mean somebody's disposition to behave in a particular way. So when we are talking about somebody's character, we say we know somebody, we're talking about all of those aspects, aren't we? We're not just talking about somebody's physical attributes or characteristics. And we kind of, as humans, would judge what other people are going to do based on what they've done before. You know what your friends like, what they may do, because, well, this is just what they like, or this is the sort of thing they do, or I know what my friend will choose when she goes into that cake shop. I just know that she's likely to behave in a way that she's behaved in the past. And so that it's kind of instinctive for us to look at things in that way. But there are specific rules of evidence about how we deal with character evidence. And so in relation to specific acts or conduct, a character trait might be identified in somebody or inferred because of the specific things that they've done. You might say that somebody has they've given money to charity in the past, and that makes them a particular person. You can infer that person therefore is charitable, I suppose, because they've given money in the past. Sometimes you might have expert opinion evidence about somebody's disposition to act in a certain way. So some scientific evidence may be based on what their past acts are, going towards what they may do or how they may have behaved in the future. They use criminal profiling sometimes, don't they? And they're looking at offences, patterns of offending, to try and work out sometimes who the offender is and whether people are likely to participate in certain crimes. in criminal cases, the court makes a distinction, though, between what is evidence that goes to propensity and what is evidence that goes to credibility. And so you need to know the difference between the two terms, and you'll see as we come on to look at the various provisions, the different aspects of character are relevant to either propensity or credibility, or sometimes both. So credibility is when somebody's character trait for honesty is used to infer the truth or falsity of somebody's testimony at trial. So that's a dishonest person, therefore they shouldn't be believed. Right? So that person's a very honest person, so therefore they should be believed. This person's never been convicted of any offence of dishonesty, no convictions, therefore we should believe what they're saying now. Okay, so that's credibility, so whether or not you believe what they're saying. And so propensity evidence is again using somebody's character traits to infer whether or not they committed the offence. So because a person has done this particular thing in the past, that makes it more likely that they've behaved in this way in this particular offence. So that their propensity to commit a crime. So you need to know the difference really between propensity and credibility and be able to distinguish them in questions. Before we come on to look at the criminal situation in more detail, the next slide is just about civil cases. And in civil cases, they're always set out there. So character evidence can be admissible in civil cases where character is a fact which is an issue in the case. An example of that might be in a defamation case, because the whole issue in the case is whether or not the person can be defamed, or whether or not what was being said about them was in fact true. So that would be the whole issue in a defamation case. So it's permissible in those sorts of situations. Character in civil cases can also be used to establish propensity for doing something. And the case there that we've given is mood music. And that's dealt with at page 276 in McConville. Mood music was about the infringement of a copyright. And the plaintiffs were the owners of copyright in particular pieces of music, and they were saying that the defendant had produced a work which was very similar, right? So breaching their copyright effectively. And the defence was that it was just coincidence, the fact that the pieces of music were similar. And so what the plaintiffs were allowed to do was to rebut that defence that it was a coincidence by showing that the defendant had also been involved in creating works which were similar to other copyrighted works that were owned by other copyright owners. So in mood music then, that character evidence was used to demonstrate the propensity for committing for breaching the copyright. And certain forms of cross-examination are allowed in civil cases in relation to character, again, so to prove somebody is biased or partial, albeit we said that's also available in criminal cases, to prove somebody's general reputation for untruthfulness. And then there are some provisions in the evidence ordinance, so section 15, which allows previous convictions to be led in civil cases. We can just have a look at that because it so the evidence ordinance section 15. Okay, so that's available also in criminal proceedings, section 15. And then the other provision that we wanted to have a look at was 62, which I think is in here also. Yeah, sorry, 62, it's at page 22, sorry, of the evidence bundle. So convictions as evidence in civil proceedings. So in any civil proceedings, the fact that a person has been convicted of an offence by or before in the court in Hong Kong shall be admissible in evidence for the purpose of proving where to do so is relevant to any issuing those proceedings if you committed the offence. And I thought that was relevant. It reminded me of the very first practical exercise that we did about when we looked at the pleadings and somebody's conviction for dangerous driving, I think, had been pleaded, hadn't it, within the civil pleadings that we looked at as practical exercise 1. Because, again, somebody's driving on a particular occasion, that was a fact and issue, so that's why it was pleaded in section 62 is what allows you to do so. So that was, again, just sort of bringing one of our practical exercises back in mind. So that's the civil situation. And so the next thing we need to have a look at is that the character evidence of the defendant. So the first thing to look at is in relation to good character. There's no presumption that somebody hasn't committed a crime just because they're of good character. Right? There's no presumption that they haven't. And nor is there any presumption that just because somebody's committed a crime in the past that they must have committed this one. It may be that if somebody's a good character, it makes it less likely that they've committed the offence charged, and they may also be more relevant to credibility. They're more likely to tell the truth. And so it is possible for an accused to put forward their good character by way of general reputation evidence. So they can't adduce evidence of specific good deeds. So that's the case of Broughton. So you couldn't say, I gave charitably on this particular occasion. I sponsored people and sponsored a swim or something. You can't specific good deeds like that. You can't give evidence of that. But then somebody's general reputation for good character is something that you're able to advance. Different rules apply to whether or not it's good character of the defendant that you're wanting to advance, or whether or not it's the bad character. So when an accused is of good character, you can use that good character to support their credibility and also to assist them in propensity. So good character can be used for both purposes. The main issue when we're looking at good character evidence really is not whether or not you can give that evidence, because you can. A defendant can go into the witness box and say, I've got no previous convictions, or call witnesses for your general reputation for good character. The issue that comes up, and there's likely to come up in an exam situation for you, is really what direction the judge should give about character. Right? If somebody's a good character, what direction is it possible for the judge to give? That is the authority of Vi, and there's also further authorities following on from that in Hong Kong. We're going to go over those in a lot more detail, I'd say, in the revision lectures. The character directions are set out in the directions pack. If you want to have a look at in McConville, it's page 249. So when you get your textbook, so look at good character directions. And so the issue is what sort of direction should the judge give? Should the judge give a direction that somebody's of good character if they've got maybe just a few convictions, but their convictions are of a very different nature to the offence that's being charged? Under those circumstances, it may be possible still to treat somebody of good character and for a good character direction to be given. The other thing that's relevant in relation to what sort of direction the judge would give, what sort of direction the judge would give, is whether or not the defendant gives evidence or not. Okay? Because if the defendant doesn't give evidence and hasn't given any statement prior to the trial, really, then a direction on credibility isn't relevant, because the defendant isn't saying anything that you need to judge. There's nothing on which you're trying to judge his credibility. If he's not giving evidence and he's not given a statement beforehand, then what is it that the jury are trying to decide in relation to his credibility? The direction in relation to propensity would still be applicable. Right? So if somebody's of good character but they don't give evidence, then they would still be entitled to a partial direction in relation to propensity. So the fact they have got no convictions may make it less likely that they have committed the current offence. The directions are at 37.1 in the directions pack, and that's quite a detailed section, I think. We just have a quick look at that. So there's a fair bit to read, really, I think, but it's helpful to read through it. But you can see there on the second page, it says 37.2 there at the top. In the box it says there's a good character direction. So start off, so you've heard that the defendant is a young man of good character, maybe not just in the sense that he's got no convictions recorded against him, but witnesses have spoken of his positive qualities. Of course, good character cannot by itself provide a defence to a criminal charge, but it's evidence which you should take into account in his favour in the following ways. And then there's the you'll see at the bottom, if he hasn't given evidence or any statements to the police, you don't give the credibility direction. But if he has given evidence, then the direction would then be given that's at the top of the next page. So the defendant has given evidence, but in the first place, the defendant has given evidence as with any man of good character, his good character supports his credibility. This means it's a factor which you should take into account when deciding whether you believe his evidence. So that's the credibility direction, and slightly different if he's made a statement beforehand, but it's still a credibility direction. That's a bit underneath it. And then the second part of the direction is in relation to propensity. And so it says this direction to propensity may be given whether or not the defendant has testified and whether or not he's made out of court statements adduced in evidence. And that direction is, in the second place, the fact that he is of good character may mean he's less likely than otherwise might be the case to commit this crime now. I said that these matters to which you should have regard in the defendant's favour. It's for you to decide what weight you should give them in this case. In doing so, you're entitled to take into account everything you've heard about the defendant, including his age and then whatever else, being on damaged character for many years, etc. with the words such as, having regard to what you know about this defendant, you may think that he's entitled to ask you to give considerable weight to his good character when deciding whether the prosecution has satisfied you of his guilt. Alright, so that those are the two parts of the good character direction, the VI direction. And so generally that's the sort of issue that you're going to be taxed with in relation to good character. It's what would be the direction that the judge would give in the particular situation that we are discussing. One other point, I think, before we move on to the next slide, is that if you choose to give evidence about your character, to adduce some evidence about your good character, then you can't just adduce part of it. Right? So in a case of, I think it's Thompson, a witness was called to establish sexual morality. Right? So that's what the witness was called to talk about, and what Thompson wanted to put before the court. He was somebody who was sexually moral. So this character witness was called, but once he was called, that witness could also be cross-examined about the defendant's convictions for dishonesty. So it wasn't possible, once he'd started to give, once he was there giving evidence about the defendant's character, couldn't restrict it just to that bit about sexual morality, exposed really the whole of the defendant's character, and the fact that and he was able to be asked questions about that. So that's good character. Then so there's more bits to consider when we're looking at the bad character of the defendant. So as we said on there, so we're looking, so the defendant's bad character. So often we're talking about previous convictions, albeit not just previous convictions. It can be other bad conduct as well. And generally, the prosecution can't adduce evidence of the defendant's bad character solely to attack his credibility, or to suggest that, because of his character, he's got a disposition to commit a particular type of offences. And I think that the reason for that is obvious. There's a risk of prejudice, isn't there? If the prosecution were allowed to do that, there'd be risk of prejudice and bias against the defendant, risks of wrongful convictions. And so that's what's known as the shield. So the defendant has got a shield so that he can't be asked questions about his previous character or previous convictions, especially unless, there are one of the exceptions applies. All right. So as with every rule, there's exceptions, and it's the exceptions that we're going to come on to look at now. So the main exceptions then to when you can cross-examine the defendant as to his bad character, or when he's put his character in issue himself, when there is similar facts, evidence, and we're going to come on to look at that tomorrow, I think. When there's something about his character that's got probative value in itself, and also when it's adduced by co-accused in a cutthroat defence situation. So those are the main exceptions. Then what we need to look at in a reasonable amount of detail are these statutory exceptions, which are set out in section 54 of the Criminal Procedure Ordinance. And then I put the top bullet point, it only applies if the defendant gives evidence. So The regime that's set out in section 54, which we're going to look at in a second, is in relation to when the defendant is giving evidence. There are some common law exceptions also, which we're going to look at tomorrow. The common law exceptions are relevant really when the defendant doesn't give evidence, right? So when he gives evidence, these are the provisions that we need to look at when we're considering whether or not the defendant's previous convictions, bad character, can be brought to the court's attention, whether that evidence can be given. So if we get section 54 out, I think that's the best thing, so that we've got that in front of us. So we looked at the other day, didn't we, the competence of defendants and their competence to give evidence. That's at the bottom of page 1. But then the bits that are going to start to become relevant to us are the bits over the page, at the top of page 2. So we know that section 54(1)(e), once you are giving evidence, then you can be cross-examined to demonstrate that you committed the offence. So we saw that, didn't we, in the Pistorius extract that we saw. So that you can be asked questions, notwithstanding that's going to incriminate you. Right? So there's no problem with that. But what these provisions do, though, is shield the defendant from being asked questions about his bad character that really would lead to the jury kind of jumping to conclusions, applying propensity reasoning. He's got convictions, therefore he's done it this time as well. All right? So these provisions are designed to prevent that. So that the first part is the bit which gives the shield. So 54(1)(f). So if a person charged and called as a witness in pursuance of this section shall not be asked, and if asked shall not be required to answer, any question tending to show that he is committed or being convicted or of being charged any offence other than that wherewith he is charged. Right? Or is a bad character unless. So that's the shield, that's the bit of the section 54 which sets out the defendant's shield. You can't ask him about his previous convictions when he's giving evidence unless one of the situations that's set out below applies. There isn't any statute definition of bad character. It's generally we're talking about previous convictions, but it can also be somebody's general disposition to commit offences. So it doesn't just have to be. So it could be that somebody's been charged on 20 occasions. They don't always have to be convictions. The other point to note in relation to section 54(1)(f) is that it only applies to cross-examination. Right? So it doesn't apply to the defendant himself. So if the defendant wants to, he can tell the court about his previous convictions. And we know that because of the way in which the statute is written, because it says he can't be asked any questions or required to answer any questions tending to show. All right? So that, you know that, he is able to reveal them himself. So why would you think somebody would want to reveal their previous convictions themselves? Do you think of any reasons why somebody might want to do that? So they go into the witness box, they're giving evidence, obviously denying the offence that they've been charged with. Why would they want to tell the jury or tell the judge about the fact they've got previous convictions? Do you think of any reasons why that might be?
Shut it down.
Yeah, it could be to show that they are honest, I suppose, couldn't it? So I suppose maybe maybe somebody has been charged with they could have been charged with a crime of violence, maybe, and or no, say they've been charged with a crime of dishonesty. That's the better example, isn't it? They've been charged with theft, and they've got convictions, but they're for fighting, right? Then you may decide to tell the court, look, I am somebody that's got previous convictions, but my convictions were associated with fighting, maybe fighting when I was a younger man. I've not got any convictions for dishonesty. So yeah, you might want to because it might be a very different type of offence like that to show honesty, or it could be, I'm being honest with the jury. I'm telling you, I do have some previous convictions. Every time I've been charged with theft, I've pleaded guilty. I always admit it, right? I always admit it if I've done it, right? But this time, I didn't do it, right? So it could be for that. So again, for that reason, that might be another reason. So kind of to show honesty. It might be because you know that the way in which you're conducting your defence, you're exposing yourself to cross-examination on your convictions, because one of those other provisions that we're going to look at in a minute applies. Because you know you are putting your own character into question, because you know you're attacking the prosecution witness's character, okay, which is one of the exceptions. If you know you've done that, then you may choose, you're going to get cross-examined on it when the prosecutor gets on his feet, you may choose to reveal that yourself, because then you've got control of how the evidence comes out, haven't you? You've got control because you're being asked the questions by your advocate. The defence advocate's the one asking you the questions. So if you know that your defendant is going to get cross-examined, better to reveal it yourself rather than let the prosecution make a big drama out of it, big reveal to the jury, right? So you're more in control of it. So those reasons may be why. We can see a number of reasons why you may choose to reveal your character yourself. So the rule doesn't prevent that. So we now need to come on to look at the exceptions. So section 54 1F1. So you can be asked about your previous convictions if the proof that he's committed or being convicted of such other offence is admissible to show that he's guilty of the offence that he's now charged with. So again, that deals with the situation where the prosecution must prove that he's as a particular element of the offence, that the defendant has committed a previous offence. Driving whilst disqualified would be an example of that, wouldn't it? Yeah. Being disqualified is an essential part of driving whilst disqualified. So the prosecution would have to prove the commission of the previous offence because it's relevant, it's an element of the offence that is currently being charged with. So that's so it is it's relevant to that. And the other point that it's relevant to, or the prosecution may use, is if it's similar fact evidence. So section 54 F1 also relates to similar fact evidence. We're going to look at similar fact evidence in more detail in the next lecture, because similar fact evidence is also a common law exception. Right, so we're going to look at that again tomorrow, I think. The section 54 1F1, when it's a similar fact, is looking at the propensity. Okay, so it's not relevant to credit. So it's not relevant to whether or not somebody should be believed. Another example of section 54(1)(f)(1) so is Attorney General and Xu Yuxing. In that case, a previous conviction was allowed to be led for somebody being a member of a triad society, because the prosecution needed to demonstrate that he knew really about the rituals of the triad society and the significance of articles associated with it. So it was probative evidence, as that's why the evidence of the conviction for being a member of a triad was allowed to be led. Then the next exception is 1F2. Right, so that he is personally or by his advocate asked questions of the witnesses for the prosecution with a view to establish his own good character, or has given evidence of his good character, or the nature and conduct of the defence is such as to involve imputations on the character of the prosecutor or witnesses for the prosecution. So 1F2 contains two separate parts, really, if you look at it. It contains an exception about when you try to give evidence of your own good character. So if you've raised your good character yourself, and then the other part of it is in relation to if you cast imputations about the prosecution, the prosecutor or the prosecution witnesses. So, and they are they're not cumulative. You don't have to do both. You know, for either will do. So it's either you reduce your own character, or you cast imputations on the prosecution witnesses. So, bringing your own character, your own good character in. You could bring it in a number of different ways. You may say, directly, I've got no previous convictions. Right? So if somebody goes into the witness box and says, I've got no previous convictions, and they have, the prosecution can put to them the fact they've got a string of offences. So if you assert your own good character by saying I've got no previous convictions, and you have, then you expose yourself to cross-examination about those offences. Cross-examination under this particular section is relevant just to credit. It's not relevant to propensity. It's just whether somebody should be believed or not. When the other, it may not just be convictions. You may not just be saying you've got convictions. It could be indirectly that you're saying you're a good character by saying, I'm a religious person, I'm a good person, I go to church, I help the elderly, I do all these good deeds. You could bring your character in that way without saying I've got no previous convictions, and potentially expose yourself to cross-examination on your character. An example of that, the case of Chong Hok Wong. In that case, the defendant testified that he was a businessman and had been working for his own company prior to his arrest. Right, so that was the impression that he's giving the jury. And in that case, it was held that the evidence was misleading because he was in fact in jail at the time. All right, so by saying, I was a businessman, I was acting for the company at the time, that was enough to put his character in issue because he wasn't actually, he was in prison. Right? So that would, in the judge in that particular case held that the defendant had put his character in issue. Another example could be by a gesture, and there's a case of Hamilton about that, where somebody turns up wearing a regimental blazer, and the judge told the person who had to remove it. It was kind of an assertion of good character, and the Court of Appeal said that was all right. And I think if somebody turns up in a holy man's outfit, whether that be a priest or something else, that could be asserting your character, couldn't it? You could see why that might be the case. Sometimes somebody turns up with a load of medals won in the army, potentially. That is, it's kind of by gesture really asserting your good character, and I think that's, would risk, dressing in that way potentially could risk exposing yourself to cross-examination on character, assuming of course there is bad character to raise. If there's no bad character to be called in rebuttal, then nothing can be put to you. But so that's how you might put your good character in issue, which could expose you to cross-examination on your convictions. It has to be really put forward by the defence, right? So the prosecution can't trick you into saying you're a good character, and then once they've done that, say, aha, we can now put your convictions in. It's got to be raised by the defence or the defence witnesses, because it would be very unfair, wouldn't it, if the prosecution were allowed to trick you into doing that. And it's got to be a clear assertion of good character. Right, so it's got to be very clear that's what you're trying to do. So there was a case where a defendant said he didn't want to name a friend who was a potential witness because he didn't want the friend to be charged with burglary. And that's what the defendant was saying. And that was held not to be an assertion of good character. It wasn't a clear assertion. If somebody asserts good character, then it is possible to be cross-examined to show the contrary. But in the case of Maxwell and DPP, this was a doctor who had been charged with illegal abortions, and in that case he gave evidence of his good character, and the prosecution tried to adduce evidence of his previous acquittal. So asked him questions about, isn't it right that you were charged previously with causing an illegal abortion, a death by an illegal abortion? And the prosecution wasn't allowed to do that because in the previous case he'd been acquitted. So they weren't allowed to assert the acquittal. Contrary to the assertion of good character. So that's putting your own good character into issue. The next, this is the other half of 54F1-2, and this is casting out imputations on a prosecution witness, either by the nature or conduct of the defence. And so for this, you need to think about what is how would you have to conduct your defence? What amounts to an imputation? What would you have to do in relation to the witnesses to expose yourself to cross-examination in this way? And again, it's something, it's got to be the way in which you conduct your own defence rather than being tricked into it by the prosecution. So, for example, in the case of Hudson, the defence put it to the prosecution witness that it was in fact that person, the prosecution witness, that had committed the offence. Okay? So that amounts to an imputation. Right? So if you were to say, in cross-examination, the prosecution witness, it's not the defendant who committed the burglary, it was in fact you. Clearly an imputation on the prosecution witness, and if the defendant's got convictions, then the prosecution will be able to put those to him were he to give evidence. So that's an imputation on the prosecution witness. Imputations have got to be against witnesses, right? So if you're saying some other random person committed the burglary, that wouldn't be an imputation on the prosecution witness. If it was just somebody not associated with the case. So the difficulty is in really drawing the line between what is an imputation on the prosecution witness and what's just an emphatic denial. Where are you just saying you don't accept the prosecution case? How far do you have to go before it becomes an imputation? And Selvey says that an emphatic denial of the offence isn't an imputation. Selvey sets out the guidelines to look at. So some further examples. The case of the Crown and Wrexham Wright. In that case, it was held the accused statement that he had been bribed to make a confession was an imputation on the police officer involved. Okay, so saying I was bribed, that's why I made the confession, that's held to be an imputation on the police officer, on the prosecution witness, and cross-examination on his character was allowed. Contrast that with the case of Westfall. In that case, the defendant just said that the constable who had arrested him had acted in an improper manner. In that case, that wasn't felt strong enough for it to expose the defendant to cross-examination on his previous convictions. And so there's a number of these examples in the case book that you want to have a look at. If you are suggesting that, if you're the prosecution, you're suggesting there's been an imputation and you want to cross-examine, you've got to get the leave of the judge before you do so. So if you think that the defendant has triggered this exception, which allows you to bring his previous convictions to the notice of the court to put it to the defendant, the judge's leave is required. And the other point to note on the slide is that in a rape case, you can say that the defendant can say that the complainant consented without exposing him to cross-examination on his character. So just saying, it wasn't a rape, she consented, right? That doesn't amount to an imputation on her character because it's just a denial, really, of an element of the prosecution case. So that doesn't amount to an imputation on her character, so they wouldn't be allowed to cross-examine on convictions in that case, and that was the case of Turner. The case of Bishop, 1975 case, I rather think that this should be decided differently now, because I think times have changed really. But in Bishop, the defendant there gave evidence that he'd been in a homosexual relationship with the prosecution witness, and it was for that reason his fingerprints were found in the witness's room, because they were in this relationship together. And in that case, it was held that that was an imputation on the prosecution witness. I wonder whether, I don't know that it will be decided in the same way today, that to suggest somebody is a homosexual is that an imputation on the character. I'm just not sure the court would find it in the same way these days. But back then, that was considered casting imputation on the prosecution witness. That's just another little slide there. So just to remind you that it has to be against the imputations against the prosecutor or witnesses for the prosecution. And when we're talking about prosecutor, it means the actual lawyer. So if the defendant starts making allegations about the lawyer conduct in the case, then that will be an imputation. Maybe just also note, it wouldn't be limited though to witnesses who testify in court. So sometimes you can have proof, can't you, by witness statements. And so if there are witness statements going before the court, or if there are depositions, we were looking at depositions before, if evidence was given in that way by the witnesses, there'd still be witnesses in the case, and so casting imputations on those witnesses would also trigger the exception, and you could cross-examine on the character. Then the next bit is about the co-defendant situation. So section 54(1)(f)(3), so he is given evidence against any other person charged in the same proceeding. So 3 only applies when you've got co-defendants. So in a joint trial, though, where the defendant gives evidence that either supports the prosecution case or undermines the co-defendant, then he'll lose his shield. Right? So he's open to being cross-examined on his previous convictions. And that's the case of Murdoch and Taylor. In Murdoch and Taylor, they were 2 defendants. One defendant was a good character, and Murdoch had got previous convictions. They were both charged with receiving stolen cameras. They were convicted, and on appeal the main question was whether or not L's counsel could cross-examine Murdoch on his convictions. And so we've got to look at what Murdoch said when he gave evidence. And what he said was, when he's being cross-examined, that the attempt to sell the stolen cameras were nothing to do with him and entirely the responsibility of L. And it was held that it didn't matter that he answered that in cross-examination, it was the effect on the jury. And so in saying that, he was giving evidence which supported the prosecution against his co-accused and also undermined L's defence. So that was, even though it was a question asked in cross-examination, that was held to be appropriate, and he did lose his shield, and it was possible to cross-examine on the convictions. So this is when one co-defendant gives evidence against the other, it's allowing the second defendant to show that the jury cannot rely on the evidence of the first defendant because of his previous convictions. So it's about his credibility. This particular sections in relation to. So particularly important on cutthroat offences where they are blaming each other. And it's not necessary always to have a direction from the judge in relation to this situation. There is one in McConville, though, that the judge may give. Perhaps if the jury have asked a question about how to deal with the evidence in this particular situation, and that is at page 245 in McConville. I think the example of the direction that a judge might give in this situation is there. So what is set out here is, so each accused is presumed innocent unless and until proven beyond reasonable doubt to be guilty. So the thought that he may have been more interested in getting himself acquitted than in telling the truth should not form any part of your thinking when deciding whether to acquit or convict him. It's, however, something which you may take into account when deciding whether you feel sure that what he says against the co-accused is true. All of this, too, is simply a pass of the law. There is only reasonable doubt as to an accused's guilt, then he must be acquitted. So that's just really a direction about when you get defendants giving evidence against each other. But it's the giving of the evidence against each other or saying something which supports the prosecution case against the co-defendant that exposes you potentially to cross-examination on your previous convictions. Then what have we got? Some final points. And so even if the defendant loses the shield, the judge retains the discretion to stop the prosecution putting the defendant's bad character into evidence. So that only applies, though, in relation to the prosecution. If you've got a co-defendant and you've attacked the co-defendant or you've undermined their defence, then the judge doesn't have a discretion to prevent your cross-examination and your conviction. So co-accused got far more freedom, really. I think we've seen that in a number of provisions. In the way in which they conduct their own defence. Then we've got traditionally bad character under section 54 only goes to credibility and not propensity, but see there's a couple of cases there. We're going to come on and have a look at these cases tomorrow, I think. So we'll leave that for now, because we're going to look at similar facts and propensity reasoning tomorrow. Then just some final points before I think we've got time to have a look at some questions. So the theft ordinance, there's just a particular statutory provision here which allows previous convictions to be led by the prosecution when a defendant is charged with handling. Right, so that, and this is, you've got this in your ordinance pack. If you want to have a look at it in Archbold, it's chapter 22, 257. So if you have somebody charged with handling, then section 29.3 of the theft ordinance says that you can admit an evidence of previous handling or convictions of theft can be admitted for the purpose of proving that he knew or believed the goods to be stolen. So if that's of relevance in a handling case, whether if somebody's saying I didn't know the goods were stolen and you want to prove that they knew they were stolen in a handling case, it's possible to demonstrate that they've either got previous convictions of handling or they've got a previous conviction for theft. And so you just need to have a look at that in the ordinance pack there. So it allows either handling convictions, recent handling convictions, or more or older theft convictions to demonstrate that somebody knew the goods were stolen in a handling trial, and it requires the judge's leave. There are common law exceptions to bad character, because as I said, section 54 only applies to when the defendant is giving evidence. It doesn't apply when he doesn't give evidence. That doesn't mean it's never possible for somebody's bad character to come before the court when they don't give evidence, but it's got to fall within the common law exceptions, which I've put up therefore on the slide for you. We're going to look at these in more detail tomorrow. All right, so we don't have to look at those now. Again, if we're not talking about the defendant, there's much less protection for them, I suppose. So if you want to put their bad character or convictions, it's just got to be relevant. Right? So you've got far freer reign, I suppose, with criticising other witnesses' character if they are, if it's relevant and it's of probative value. You just see what exercise 14 was in the pack. I'm not sure that we're going to have time to look at that now. Let's just see what it was. Oh, just while we're passing, actually, exercise 13 in the pack, we haven't done that. The reason we haven't done it is because it's asking you to read this, the case of Vi is set out for you in your in the unit guide, and so you need to read that in order to do practical exercise 13, right? So that's why we haven't done it now. So you can do that. I don't know whether you'll have time in the morning to do it. I know it's late now, isn't it, when you get home, but try and have a look at that. And if you get a chance to do it, then I'll give you the answers to that tomorrow. So if you have a chance to have a read through, guys, no, it's not too long. Have a look at that. And then practical exercise 14 is the next one. So this is asking about let's have a look at this, and then we'll see how we've got about, I think, a few minutes before I'm meant to finish. So we've got time to look at this. I know it's Friday night, so we'll just try and get on as far as we can, and then we'll maybe finish some of this stuff up tomorrow, and everyone's feeling pressure. Let's just look at this last one then, maybe. Right, so have a look at that and see if you can work out what to do, what the answers are. he got on with that? He worked out what could happen. This is just a sort of scenario really that can come up in the exam question. You'll see we've got an exam question which we're going to look at tomorrow, but just this sort of thing, right? So, you know, number of defendants, different situations, different convictions, etc., and you know what happens in cross-examination. So, Henry, James and Albert jointly charged with burglary. Henry and James both with a previous conviction for theft and 2 previous convictions for burglary. Albert's got a previous conviction for obtaining benefits by false representations. The only evidence that connects him with the crime is that of Sam, who claims to have driven the getaway car and is now giving evidence to the prosecution. Sam has got 1 previous conviction for burglary and 1 for obtaining property by deception. Henry's counsel wishes to cross-examine Sam about his previous convictions. Can he do so? If he does, will the prosecution be allowed to adduce evidence of Henry's previous convictions? The answer is yes. You can cross-examine Sam about his previous convictions if he wants to, but he's going to lose his shield if he does. That's section 54 1F2 is casting imputations on a prosecution witness, because he's effectively saying, isn't he, don't believe him because he's got previous convictions. So because of his bad character, don't believe him. That's effectively what he's saying by cross-examining him on his previous convictions. So Henry would lose his shield. James is the next one. James says in evidence that Sam is a liar. Can the prosecution adduce evidence of James's previous conviction? And yes, directly calling somebody a liar is an attack on their character. So James would lose his shield. Again, it's a attack on the character, 54 1F2, and the prosecution can cross-examine on previous convictions. Next one is Albert says in evidence that Henry, James and Sam invited him to help with the break-in, but he refused and did not take part. Can Henry's counsel adduce evidence of Albert's convictions? Yes, he can, because the way in which Albert's conducting his defence is effectively saying that Henry, James and Sam committed the offence, right? So he's undermining their defence, isn't he? Because he's saying they did it. Or assisting the prosecution case. So section 54 1 F3. Then the final one is, what about Albert wishing to cross-examine Henry and James about their previous convictions for burglary? Can he do so? Yes, he can. He can adduce whatever evidence he wants, but he's going to lose his shield because section 54 F13. Remember, if it's the prosecution trying to adduce previous convictions, the judge has always got a discretion to prevent cross-examination, but not as between co-defendants. Once the co-defendant, section 54 F3 is in operation, co-defendants don't need leave, so the judge has got no discretion to prevent it. And in all of those cases, the previous convictions are relevant to credibility, not to propensity. All right? I think that you've worked hard enough, so I'm going to let you go a whole minute early. And I'll see you tomorrow at 2:30. Have a look at that exercise, whatever it was, 13 if you can, and I'll give you the answer to that tomorrow also.